defendants. Therefore, they are not recognized legally as the defendant counsel in this case. In the circumstance, I hereby find that the defendant did not enter appearance, neither did it defend this case. I accordingly framed the following issue for the resolution of the court in this case. 1. Are the claimants entitled to the court's declaration that the defendant has no legal justification for withholding their salaries and entitlements after they duly executed their part of the contract? Does the conduct of the defendant in this respect amount to an unfair labor practice? 2. Are the claimants entitled to claim from the defendant a total sum of 11,480,000 naira as their severance and joint entitlement basis of the contract? Are the claimants entitled to interest on the total sum claimed and on the judgment sum at 22% interest per annum? From January 21 until the judgment sum is liquidated, are the claimant entitled to the sum of 3 million naira for unfair labor practice? Now, resolution of the issue framed by the court. Issue 1. Are the claimants entitled to the court's declaration that the defendant has no legal justification for withholding their salaries and entitlements after they had duly executed their part of the contract, in order to show the court that they were employed by the defendant to work on its two-phase contract? The claimant tendered their letters of employment as Exhibit C1, C7, and C8 respectively. See pages 21, 24, and 28 of the court record for these letters. The content of these letters of employment are essentially the same, except for each claimant's name, the post for which he was employed, and his salaries. Also, Exhibit C2 and C3 at pages 29 and 31 of the court record are the claimant's evidence of work done for the defendant on the second phase of the job or contract. These two exhibits are in tabular form on the letterhead paper of the defendant and with its logo. However, the letter of employment of the first and the third claimant are not signed. See Exhibit C1 and C8, particularly at pages 21 and 28 of the record. The effect of this unsigned document is that it has no evidential value. Furthermore, Exhibit C2 contains some typed information, but it is not also signed. Therefore, Exhibit C1, C2, and C8 in this case are hereby discountenanced in this judgment because they have no legal value. Are you people listening? James? James?
Yes, my lord.
Can you people hear what I said, what I read out? You heard it, that I said that Exhibit C1, C2, and C8 in the case are hereby discountenanced in this judgment because they have no legal value?
As the court pleases.
That's what I need, the response I needed. That will show me that you are listening.
As the court pleases.
Okay. Nevertheless, the letter of employment of the second defendant is adequately signed by one Augustine Ozagu, the general manager of the defendant. See Exhibit C7, particularly at page 24 of the court record. Again, Exhibit C3 included the names of the three claimants among the workers who participated in the second phase project of the defendant in January 2021. It is signed by the supervisor and the project manager on 3/1/2021. See page 31 of the court record. In addition, Section 91 of the Labour Act defines contract of employment to mean, and I quote, any agreement, whether oral or written, expressed or implied, whereby one person agrees to employ another as a worker, and that other person agrees to serve the employer as a worker. End of quotation. Generally speaking, a contract of employment is an agreement between an employer and employee, whereby the terms and conditions of employment are stipulated. Two decided authorities are referred to there. From the definition of the contract of employment in Section 91 of the Labour Act, a contract of employment can be an agreement between at least two people, either orally or in writing. It can even be implied, whereby one person agrees to engage another as a worker, regardless of the fact that the letter of employment of the first and third claimant are discountenanced in this judgment. It is before the court in their pleadings and evidence that they were employed by the defendant for its contract with effect from November 26, 2020 to January 4, 2021, and that they worked on that project. See the evidence of CW1 at pages 9 and 10 of the court record. The defendant was served with the pleadings and the evidence, and this evidence, the written statement on oath of CW1, but it never controverted it. Neither did it challenge it. The law is right that evidence that is neither challenged nor discredited should be accepted and relied on if such evidence is adduced to establish a relevant fact. Two decided authorities are referred to there, particularly the Supreme Court case of Amadi versus Olu, where the Supreme Court held that evidence which is admissible, which is unchallenged and uncontroverted, which is in line with the parties pleading and is not manifestly incredible or unbelievable, ought to be acted upon by the court. Since the defendant did not challenge the claimant's evidence on this issue, I believe the pleadings and evidence of the claimant, and I hold that the defendant admitted this fact. Consequently, I hold that the defendant employed the claimants to work on its project from November 26, 2020 to January 4, 2024. As court pleases, right?
As the court pleases.
Yes. Then I say I hold that. You as court, you should be pleased with it. Okay?
Yes, my lord.
Okay. In paragraph 6 to 10 of the claimant's pleading and evidence of CW1, the claimant satisfied the court that they adequately finished their work on the two-phase contract for the defendant, but that the defendant did not pay them their agreed sum for the said services rendered. The defendant did not give any evidence that it has paid the claimant, neither did it give any justifiable reasons for not paying the claimant for the work done. In the circumstance, I find and hold that the claimants are entitled to the court's declaration that the defendant has no legal justification to withhold their salaries and entitlement after they had duly executed their part of the contract. And I so hold.
As the court pleases.
Does the conduct of the defendant in this case, in this respect, amount to an unfair labor practice? The phrase unfair labor practice is a statement of fact on which the claimants have a burden of proving what they meant. What they meant by unfair labor practice towards them against the defendant. If they support their evidence with foreign decision on the issue, it may make their explanation more persuasive. But once they establish the unfair labor practice meted on them by the defendant satisfactorily, it becomes the duty of the court to use its objective criterion of what is unfair to arrive at a decision. Commonly, where an employer acts outside of the pale of bona fide, that is, within the pale of mala fide, in excess of its power, inequitably, unreasonably, vindictively, and in victimization of the claimant, the employer is said to be unfair to its employee in labor practice. In the case of Ogunyale and others versus Global Consultation Supplied, a decision of the president of this honorable court, Honorable Justice B.B. Kai, PhD, OFR, the court held on what amounts to unfair labor practice that the following situation amount to unfair labor practice. One, an employer compelling its employee to bank with a bank the employee has no interest in. Two, non-issuance of pay slip to indicate their monthly salaries. And three, non-issuance of termination letter to an employee. End of quotation. Other instances where this court declared the action of employer as unfair labor practice are: one, in the case of John Mohotel versus OK Isokariari and Sons Nigerian Limited, unreported suit number NICMPAC 64, 2022, judgment of which was delivered on July 16, 2024 by Honorable Justice Amsa. It was held that failure of the defendant to accord the claimant opportunity to enjoy his annual leave for over a period of 5 years was an unfair labor practice. Two, in the case of Obembe Kikelomo versus First Royal Oil Nigeria Limited, unreported suit number NICN LA 110/2020, judgment of which was delivered on October 3, 2024, per Honorable Professor Elizabeth A. Oji. The court held that undocumented employment status / refusal to issue letter of employment for over 10 years of working with the defendant as unfair labor practice. And three, see also Professor Aderonke Favor Betty Thompson versus Governing Council Federal University of Technology, Akure, unreported suit number NICN AK01 2024, judgment of which was delivered by Honorable Justice K.D. Damalak. In the instant case, the claimant established the fact that after working for the defendant on the two-phase contract as agreed, it failed to pay them the agreed remuneration for the job. In my considered view, that was done mala-fide in excess of its power. It was done mala-fide in excess of the defendant's power. It is inequitable, unreasonable, and vindictive. And I so find, I hold in the circumstance that the deliberate refusal of the defendant to pay the claimants their wages and entitlement after completing their part of the agreement in the terms of the contract of employment amount to unfair labor practice.
As the court pleases.
Are the claimants entitled to claim from the defendant a total sum of 11,480,000 naira as their severance, as their several and joint entitlement for working with the defendant on its two-phase contract of employment? It should be noted that the employment contract between the claimant and the defendant is a private one, formerly known as master and servant relationship. In determining the rights and obligations between the parties in this contract of employment, the court is required to look at the documents governing their rights and obligations. A decided authority is referred to there. I have found above that the content of the second defendant's appointment letter and the chart table, which is Exhibit C7 and C3, showing the claimant's participation in the second phase of the defendant's contract are relevant and applicable to this case. I therefore hold that these two documents governs the contract of employment between the parties.
As the court pleases.
Furthermore, I have held above that the three claimants were employed by the defendant from the testimonies of the claimant that the defendant had agreed to pay the first claimant the sum of 35,000 naira, and to pay the second and third defendant 70,000 naira per day each, respectively, at the end of the first phase. See clause 5 of Exhibit C7, the letter of employment of the second claimant in this case, the pleadings and testimonies of the claimant as well. The claimant again contended that the first phase of the defendant project was with effect from 26th of November 2020 to December 23, 2020, which is a total of 28 days. See paragraph 5 of CW2, that's the second claimant evidence at pages 17 and 18 of the court record. They went on that by the parties' agreement, the payment shall be made by the defendant at the end of each month, on or before the 10th day of the succeeding month. Based on the foregoing, I find and hold that the first claimant is entitled to the payment of the sum of 35,000 naira daily multiplied by 28 days, which equals 980,000 naira, while the second and third claimants are each entitled to 70,000 daily multiplied by 28 days, which equals 1,960,000 days each, respectively. I further hold that the total entitlement of the claimant from the defendant for the first phase of the contract is the sum of 4,900,000 naira. As court pleases, right?
As the court pleases.
Yes, that's for the first phase. In addition, the claimant stated that the second phase of the contract with the defendant commenced from December 23, 2020 to January 4, 2021. which is a period of 12 days. The document supporting this claim is Exhibit C3, which is the timesheet in respect of the period the claimant worked in January 2021 on the second phase of the contract, and which the court has held to be satisfactory. In paragraph 4B of their pleadings, the claimants averred that for this second phase of their job, the parties agreed that if the job could be completed within 10 to 14 days instead of 28 days, they will be paid additional bonus of 20,000 naira per day, together with the agreed entitlement paid on the first phase of the contract. In essence, for this second phase of the contract, parties agreed that for the first claimant, Alex Ray Ekokota, level 1 rope access technician, we earn 35,000 naira per day plus 20,000 naira per day, which equals 55,000 naira per day, multiplied by 12 gives us 660,000 naira. The second defendant, Eyitemi Prince Ochei, level 3 rope access technician, supervisor, we earn 70,000 per day plus 20,000 naira, which equals 90,000 naira per day, multiplied by 12 days, which equals 1,080,000 naira. The third defendant, Otaru Alexander, level 3 rope access technician, supervisor, we earn 70,000 naira per day plus 20,000 naira, which equals 90,000 naira per day, multiplied by 12 days, gives us 1,080,000 naira. I therefore find and hold that the total entitlement of the claimant for the second phase of the contract is 2,820,000 naira. Consequently, I hold for the first and second phases of the parties' contract in the instant case that the claimants are entitled from the defendant jointly and severally a total sum of a total sum of 7,720,000 naira. That's my decision. The total sum that they are entitled to is 7,720,000 naira.
As the court pleases.
Okay. Are the claimants entitled to interest on the total sum claimed and on the judgment sum at 22% per annum from January 2021 until the judgment sum is liquidated? Relief 4 of the claimants is for 22% interest on the pre- and post-pay judgment interest on the monetary claim and judgment sum. Order 47, Route 7 of the Court of the National Industrial Court Civil Procedure Rules 2017 provides that at the time of delivering its judgment or making an order, give direction as to the period within which payment is to be made or act is to be performed. The court may order interest at a rate not less than 10% per annum to be paid upon any judgment. By virtue of this provision, therefore, the claimants are not entitled to any prejudgment interest as claimed, and I so hold.
As the court pleases.
I further hold that the claimants are only entitled to interest on post-judgment sum and this discretion will be exercised at the appropriate point in this judgment, and I so hold.
As the court pleases.
Are the claimant entitled to the sum of 3 million naira for unfair labor practice? I have held in this judgment that the deliberate refusal of the defendant to pay the claimant's entitlement after performing their own obligation of the contract since year 2021 till date amount to unfair labor practice. In my considered view, the claimants have surely satisfied, the claimants have surely suffered untold hardship for the defendant's refusal to pay them their entitlement. Consequently, I find and hold that the claimants are entitled to damages for the defendant unfair labor practice, and I hereby direct the defendant to pay to the claimant jointly the sum of 1,500,000 naira as damages for their unfair labor practice.
As God pleases.
On the whole, I hereby hold, declare, and order as follows. I hold and declare that the defendant has no legal justification for withholding the claimant's salaries and entitlement after they had duly executed their part of the contract. 2, I hold that the conduct of the defendant in refusing to pay the claimant's entitlement in the instant case amount to unfair labor practice. 3, I hold that the claimants are entitled to claim from the defendant a total sum of 7,720,000 naira as their several and joint entitlement for working with the defendant on its first and second phases of the contract. 4, I hold that the claimants are only entitled to post-judgment interest on the total judgment sum. 5, I hold that the claimants are entitled to the sum of 1,500,000 naira as damages jointly for the defendant on fair labor practice. I hereby direct the defendant to pay to the claimant the total sum of 9,220,000 naira only within 30 days from today. After which the judgment sum will begin to attract interest of 15,000 naira, 15% per annum until judgment is fully liquidated. Judgment is entered accordingly, and the defendant shall pay the sum of 500,000 naira to the claimant jointly as cost of these proceedings.
As the court pleases.
So I will send the judgment. I will send copy of the judgment to Port-Harcourt for sending to you. I hope they will deliver it on time by courier through our office here.
Yes.
Okay. Okay.
Hello.
Yes. I can't hear you.
As our final written address, my Lord, we did mention the cost of 70,000 awarded against the defendant, which we stated in our final written address and adopted on the day of the adoption.
Can you remind me? Let me check my record. When was that cost awarded? Let me check my record. When was that cost? What date was the cost awarded?
Just vacated.
You said? If you remind me of the date the cost was awarded on.
Yes, on the 9th of May, 2024.
9th of what?
9th of May, 2024.
9th of May. 9th of May.
Yeah, 2024.
Okay. Yes, that is at page 17 of my court record. That day, the court said the matter is adjourned to July 16, 2024 for mention. In Port-Harcourt, the defendant is to pay 70,000 naira cost to the claimant before then. 70,000. So has that cost been paid?
No, my lord, it was paid
The defendant has not. That's the claimant counsel. Mr. Let me see your name again. One name is long. Oh no, Ajo. Yes, Mr. Uno Ajo Fair.
Yes, my lord.
On what date now? On
May 2024.
9 May, 9/5, right?
Yes, my lord.
9/5, 2024.
Yes, my lord.
The court awarded some Did you say the cost has not been paid or it has been paid?
It has not been paid. It has not been paid, my lord.
Mr. Kiado,
Yes, my lord.
even though you are in the court, since you are not legally recognized in this file until I gave judgment, all you need to do is to listen so that you will know how to collate your point together when you are going to the court of appeal. Okay?
My lord, it is not in our discretion to go. Advise our client appropriately.
Okay. Because yes.
My
Okay.
lord, just to
No,
plead
let
with
me finish
my
with
lord,
this issue. You said what?
if my lord can graciously vacate the order of
Which
court,
order?
my lord, the one made on the 9th day of May 2024, awarding the cost of 70,000 in favor of the claimant. Since we pleading with my lord and with
You know that is not possible. Just hold on.
if
I'm not listening to you. You are not supposed to be heard, counsel. You are not supposed to be heard. You are not supposed to be heard. From the court record now, from the court record,
As the court pleases.
There is writing something now. Okay.
I'm still writing. I'm still here.
Okay, my lord.
Tell them I'm still here. When I'm ready, I'll tell them.
Okay, my lord. Yes. Campus.
Page 16. I think. Page 16, 17, 17.
Somebody brought the person. They have to pay me for transport back. Terrible manliness. Terrible, you know. Yeah,
What's that? James.
My lord.
What is making noise?
Yeah, try to check
what
mute
I
our
have
this thing.
here is that,
Yes, my lord. You are trying to mute our.
Okay, just listen, just a
speaker.
minute more. I'm done. From
Okay,
the court record, on 9th May 2024, I confirmed that this honorable court awarded the sum of 70,000 naira cost against the defendant and in favor of the claimant. See page 17 of the proceedings file. This order is still standing, is subsisting, and the defendant shall comply with it.
As the court
pleases.
Good. So that's the end of the proceedings. Nobody is appreciating the court.
Lord, I thank you for all the travails and the pains you've gone through. You are supposed to be resting, Lord, but you took the pain and the save and relieve my client and all our suffering. I thank this honorable court, my Lord. I wish you a pleasurable vacation, not a stressful one like this, my Lord. Thank you, my Lord. We are grateful for this judgment.
My Lord, on behalf of the defendant counsel, even though I'm not proper before your Lordship, we commend my Lord's industry for putting up time and to weigh in our works to deliver this judgment during vacation. From the bar, we pray that may Lord continue to grant your Lordship the strength in the discharge of your duties. We are most grateful, my Lord.
Thank you. Okay, that's the end of the proceedings. Thank you very much. Okay, bye-bye.
Thank you, my Lord.